Flamand. I'm here to meet Lisa Kruger-Kahn, immigration attorney in Central Florida. Let's see what she has to say. Hi Lisa, can you tell me about your company and what it is you do here in Orlando?
Absolutely. So I have an immigration law office. I practice exclusively in the area of immigration law and have been doing that for 21 years, just immigration. I handle all aspects of immigration, both employment-based and family-based immigration. I'm a sole practitioner, and I have a support staff, legal assistant, and a receptionist. And I love what I do. It's my passion.
With the change of presidency, can you tell me if you've seen any negative changes?
Yes, it's been an interesting time in the immigration world and with the new administration that is kind of tough on immigration. What I have seen as far as changes have been largely with adjudication standards. Everything seems to be getting tougher. So cases in the past that might have sailed through a little bit more easily seem to have a little higher degree of scrutiny. There is a kind of Buy American, Hire American policy and directive from the current president, and that's trickling down to the lower levels. The immigration system as a whole is largely unchanged and has not really changed that much in the 2 decades that I've been practicing, but I do see things getting tougher. So it's a little bit more challenging environment. I think it's probably more important than ever for someone who's immigrating to the U.S. or wanting to come to the U.S. to work with a professional. Doesn't have to be me, but I think it's a good idea for someone to be represented by an immigration attorney because they're tougher waters to navigate these days. There have been some other changes too, which have been, I think largely in the news with regard to certain travel bans for individuals from certain countries and an uptick as well in deportation and people who are being put into removal proceedings that in the past may not have been. For example, individuals that may have come to the U.S. lawfully but have overstayed their lawful period of time but don't have a criminal issue or might have some family ties weren't a high priority before for the government for deportation, and now everyone is fair game. And so there's definitely been an uptick there with the current administration.
I take it that it is a little bit more complex to file for a visa. However, it is not impossible. It is still according to what used to be the regulations, I'm assuming.
Absolutely. Nothing is impossible, that's for sure. But I think it's just maybe a little bit more challenging. Certain visa types have seemed to be largely unaffected. I handle a lot of E2 investor visas, and those, fingers crossed, seem to be moving along and still kind of proceeding, business as usual. It's more the filings with immigration here in the U.S., certain visa types like H-1B visas or L-1 visas that seem to be subject to a little bit greater scrutiny.
Can you tell me what options foreign nationals have when obtaining a visa?
That's a short question with a long answer.
Yes, I know.
So it really depends on the circumstances and on the individual's background and family ties and where they're from and what they want to do here and if they've got funds to accomplish their goals and what their prior maybe work history has been, educational history, etc. In general, the immigration system kind of falls into 2 camps, and that's family-based immigration, where someone is able to immigrate based on a family relationship. Perhaps they're marrying a U.S. citizen, or they have a brother or sister who's a citizen and had filed for them to immigrate years ago, or there's some close family ties. Generally, it would be a spouse, parent, child, or sibling. Aunts, uncles, great-grandparents. It doesn't really help that much. Absent close family ties, generally then we have to look at employment-based immigration. And within the employment-based context, we've got non-immigrant visas, which are temporary work-related type visas, although many can be long-term even though they're temporary. And then we have immigrant visas, which really is another way of saying permanent residence or a green card. A lot of folks will come in first on some type of a work-related, employment-based, non-immigrant visa, and then try to turn that into permanent residence. So there's a variety of visa types. They've got classifications that are kind of letter-based. We have visas such as an E2, which is an investor visa. It's called a treaty investor visa, so an individual has to be a citizen or national of a treaty country, and there's a list of countries that are eligible for the E2 treaty investor visa. So one's nationality is important for that type of visa. There's an E1 treaty trader visa where one is engaged in substantial trade between the U.S. and their home country. We have an H-1B visa, which is where someone has a job offer from a U.S. employer in a position that's specialized and complex enough that it's normally associated with at least a bachelor's degree. And that's an H-1B visa would be a visa for those specialty occupation workers. There's an L1 visa, which is for intra-company transferees, where someone's worked for an overseas company for at least a year as a manager or an executive or a professional that has specialized knowledge, and they're now being transferred to the U.S. to work for a related entity here. Or they're setting up or involved in setting up a new affiliate or branch office in the U.S. That's an intra-company transferee, an L1 visa. We have an O1 visa, which is for individuals who have extraordinary ability in their field, kind of the best and the brightest or the top of one's game. That could be business, it could be athletics, it could be the arts. There are special visas for athletes, for entertainers. We have an R visa for religious workers. There's a TN visa under NAFTA, which is for Canadians and Mexicans who have a job offer in the U.S. and are holding a professional position. There's also an E3 visa, which is for Australians, and it's very similar to that TN for professionals. So there's a whole variety of non-immigrant visas, and I think one of the important things for someone who might be interested in coming to the U.S. and isn't sure, how it could work for them would be to meet with an immigration attorney and have an in-depth discussion about what are the options, what are your goals, what would you like to achieve in the U.S., what would you like to be able to do, and can we make it happen? And that's largely what I do when I meet clients for the first time. We'll do a consultation either in the office or by phone or Skype, and I'll get a sense of someone's background and what it is that they'd like to do, and then we explore whether there's options to do that. Sometimes there's multiple options, and sometimes there's very few options. But we always try to, leave no stone unturned and see what may be doable for clients. Those visa types that I mentioned are all non-immigrant work-related visas, and then as indicated too, we have immigrant visas, which is a green card, and then there's other categories for permanent residence as well. And those categories based on employment, there's a category for extraordinary ability. There's a green card category for outstanding researchers and professors. There's a category for multinational executives and managers, very similar to the L1 that I mentioned. We have a category for religious workers as well. There's a process called labor certification where a U.S. employer can go through a good faith recruitment or advertising effort, and if they're unable to find a U.S. worker who's willing, able, qualified, and available for a particular position, then Department of Labor will certify a foreign worker who meets all the criteria for the position for the job, and that can be a basis for someone to immigrate. That's called labor certification. We also have an investor visa called an EB-5. It's the employment-based fifth preference category. That is an investor visa that will lead to permanent residence. Very different than the E2 non-immigrant visa that I referred to earlier. The E2 requires a substantial investment into a business, and an individual who's coming to direct and develop a business that's not a marginal one might be an investment of $100,000 or so. With the EB-5, the EB-5 was originally created for investors who are going to directly invest $1 million or more into a new U.S. business and create at least 10 full-time jobs for U.S. workers. If the investment's in a rural area or an area of high unemployment, then the threshold is $500,000. When that program first came out, it was underutilized. There just weren't that many foreign investors putting $1 million into a new U.S. company and hiring 10 full-time U.S. workers. Now that program has morphed more into indirect investment, which entails what are called regional centers, and those are investment projects around the country which require maybe many millions of dollars to come to fruition, and individuals can indirectly invest into one of those designated projects, usually $500,000. Most of those projects are in areas that are either areas of high unemployment or rural, and so the projects will take maybe 10, 20, or many foreign investors, and they'll take $500,000 investment from each of those, and based on that project coming to pass, the jobs that are created overall from that project, they'll attribute 10 jobs to each of those investors, and that's become an increasingly popular way for individuals to receive a green card.
Plenty of options, I think.
A lot of options. And then that's not even everything. We've got a diversity visa lottery program too. That's something that the president has talked about possibly doing away with, but it still stands for the moment, and that's for individuals from countries where we don't have a lot of immigration, can apply each year, usually around October, November, and kind of put their name in the hat for a lottery to win a green card. And I've had clients who've won a green card and gotten permanent residence that way.
That's how I got mine.
Oh, I didn't know that.
Yes. Okay, can you take me through the process of a regular E2 visa?
Okay, sure. So the E2 visa is a treaty investor visa. The first thing that I would do as an immigration attorney is to make sure that an individual who would like to come in on an E2 investor visa has the nationality or citizenship of a treaty country. There are certain countries where we don't have an E2 treaty. For example, Venezuela, Brazil, India. Many countries where we do. Many European countries, the UK, Belgium, Switzerland, etc. So the first thing we want to do is identify whether the individual has the nationality of an E2 country and can potentially apply for an E2 visa. The E2 criteria are that one is making a substantial investment into a U.S. business, that they're coming to direct and develop that business, and that the business is not marginal. So I always say the most important part of the E2 visa is figuring out, well, what is an individual wanting to do? Do they want to buy an existing business? Do they want to start a business from scratch? Do they want to go into partnership with an existing business owner in the U.S.? All of those would be different options and different ways of obtaining an E2 investor visa. We would need to show that an individual is making substantial investment into a business. Substantial investment is really relative to the nature and value of the business that someone is investing into. Generally, as kind of a general rule of thumb, a substantial investment is about 75% or more of the value or maybe the purchase price of a business. So if someone is looking to buy a business that's worth $150,000 and they're going to pay $150,000 cash, they're making a 100% investment, that's substantial. In that same scenario, if they're investing $130,000 and the seller is willing to finance the balance of $20,000, maybe in a promissory note paid over a couple of years, that's still a substantial amount. $130,000 relative to the value of $150,000 is a substantial amount. In that scenario, if someone has $10,000 to invest and they want to finance $140,000, not going to work for the E2 investor visa. With the E2 investor visa, we need to show that an investor is coming to direct and develop the business. Generally, that's relatively easy, even if someone is going into a new field. Perhaps they were a retired police officer and now they want to buy a pool cleaning company. It doesn't matter if someone doesn't have the experience or background in the business venture that they're now investing in, as long as we can tie in some skill set and ability to be able to direct and develop a business here. We also need to show that the business is not marginal, which essentially means that the U.S. business is one that can generate enough income through salary and or profit to be able to support the investor and his or her family above kind of a subsistence level, and ideally create some employment for others, which can be direct employees, part-time, full-time, or independent contractors as well. With the E2 visa, most of the time we would be filing for the E2 visa directly with the U.S. consulate or embassy in one's home country. Each consulate's a little bit different as far as the criteria and documents that are required. And that's something that we would go through with clients, and oftentimes we're working in tandem with business brokers as well in getting all the documents that are needed for the visa. We have to show that the funds that are being invested come from a lawful source, so we have to show a paper trail of where the investment funds are coming from. Time frames for the E2 visa vary a little bit from consulate to consulate. I would say the faster consulates, from the time of submitting the E2 documents, might be able to get an appointment, say, in 2 weeks or so. That would be the case, for example, with Toronto. They're relatively quick and efficient, and once documents are submitted electronically, then the appointment can be made online. Other consulates, we have to submit the documentation and allow time for the embassy to review all the materials, and then they'll contact us when they're ready for an interview. For example, the London Embassy, where we do a lot of E2 filings, they're taking about 30-ish days or so, maybe 45 days, to review an E2 application, and then we go and make an appointment online. And the appointments might be available within the coming week, or there might not be appointments available for a few weeks. So it varies a little bit depending upon the workload and other issues like that.
But it's a very straightforward process, I think.
Generally so. And what I'll tell clients is the important part is that we vet the case and make sure that we've got a solid case before we submit anything. I would never submit anything if I didn't feel it was clearly approvable. That said, I always tell clients I don't get to make the ultimate decision, so I can't give a 100% guarantee of success for any type of an immigration case, but I wouldn't submit anything that I didn't feel is clearly approvable, and we've got a very good track record. If there's going to be a problem or an issue or grounds of ineligibility, we're going to come across that or discover that while we're putting the case together and not after the fact.
Can you take me to the process of an L1 visa?
Sure. So the L1 is an intra-company transferee visa. It's an L1A visa and an L1B visa. The L1A is for multinational executives and managers, and then the L1B is for specialized knowledge professionals. For the L1, a foreign worker has to show that they have worked for a foreign entity for at least 1 year in the last 3 years in an executive or managerial role or a professional with specialized knowledge, and that they're now transferring to the U.S. to work for a related entity here, parent, branch, affiliate, subsidiary of the foreign employer, and that they're going to take up a position here that's executive, managerial, or specialized knowledge professional as well. With the L1, I think it was originally designed for multinational corporations to be able to transfer personnel among offices. It's relatively straightforward for large multinational corporations with a lot of staff for high-level executives and managers. It's possible to do an L1 for smaller businesses as well, but if the businesses are too small, it's difficult, especially for executives or managers. So for example, if we have someone who perhaps has owned their own business overseas, let's say they have an engineering company with 30 employees and it's been an ongoing concern for several years, and now they're going to set up a new U.S. company and they want to come in and set up the new office here and transfer in under the L1, that could be a good fit, showing that they have been an executive or manager for the foreign company, that company will still operate, and that they're now setting up maybe a branch office or subsidiary here. It might be the same field. They may be setting up an engineering company here and doing very similar work, or it might be something completely different. For example, maybe they've had an engineering company overseas, and now they're buying a large restaurant that has already been up and running here in the U.S., and now they're going to direct and develop that business. That can be doable for an L1, even if it's a different field. The tricky thing is when the businesses are very small. So if someone has kind of a mom and pop business overseas, maybe they manage rental homes and it's just a husband and wife team with very little employees, that's going to be a very, very tough L1. To show that someone truly is an executive or a manager, immigration loves to see subordinate staff, and they like to see things like organizational charts and payroll records. They want to see that an executive or a manager is removed from doing the day in and day out activities of the business and is largely involved in directing and developing the business, setting the policies, goals, and supervising subordinate staff.
What's an EB-5 and who does it apply to?
So EB-5 stands for Employment-Based Fifth Preference Category. Within the employment-based immigration system for permanent residents or a green card, we've got various categories. The employment-based first, second, third, fourth, fifth. And the fifth preference category is for investors. The EB-5 originally was designed for individuals who are making a substantial investment of generally $1 million or more into a new U.S. business and creating at least 10 full-time jobs for U.S. workers. If the investment is in a rural area or an area of high unemployment, then the threshold amount is reduced to $500,000, but there's still a requirement to create the 10 full-time jobs for U.S. workers. And those have to be full-time direct W-2 employees, not subcontractors. When the program first came out, it was underutilized. There just weren't that many foreign investors that could or needed to invest $1 million or more into a new business and hire the 10 full-time U.S. workers, and the two go hand in hand. So sometime after the program came out, it morphed into what we call indirect EB-5. And that is where an individual is investing into what are called regional centers. And those are investment projects around the country that have been designated by immigration for purposes of EB-5 indirect investment. That's where an individual can indirectly invest typically $500,000. Most of the regional centers are designated for the lower threshold investment. They may be in targeted employment areas or areas of high employment or rural areas. And what those projects do, they will accept multiple foreign investors, each putting in $500,000. And when the project comes to fruition and creates the jobs, they'll attribute 10 of those jobs to each of those individual foreign investors. So that's a way for individuals to be able to obtain a green card by indirectly investing into one of these regional centers. The tricky thing, I think, with the EB-5 is that an investor really has to do their homework on the regional centers. There have been problems where regional centers have gone bust and individuals have not only lost their investment but not received a green card, or maybe received a green card and then subsequently lost the green card if the project failed. With the EB-5, the green card or permanent resident card is initially issued for a 2-year conditional period to make sure that the jobs are really being created and that the project does move forward. And so there have been times when individuals have gotten that 2-year card but may not have then gotten the 10-year or permanent card thereafter. So it can be a good way for some to get permanent residence, but definitely need to vet the regional centers very carefully.
Golden visas exist in Europe. Does it exist in the US?
Well, by golden visa, if you're referring to a retiree visa, the answer is no. We don't have a retiree visa in the U.S. In the past, there had been some lobbying efforts, and I think a congressman or two that tried to promote something like a golden visa or a silver visa for retirees, maybe tied into home ownership and a certain level of net worth, but we don't have a retiree visa, which is unfortunate for many. Folks that would like to come to Florida, for example, where I practice, and retire here, have to look at different alternatives. It may be that they're going to spend part of the year. We have a lot of Canadian snowbirds that may come down and spend the winters here and the summers back home. That can be accomplished under a B1, B2 visitor visa. The visitor visa will allow an individual to come to the U.S. and stay for up to 6 months at a time. If they're not living permanently here and working here. For a visitor visa, one needs to show that they still have a permanent residence and a home outside the U.S. and that they are visiting the U.S. So it may be a way for people to quasi-retire on a visitor visa. For some that might like to retire and be here full-time but don't want to work perhaps as hard as they worked in the past, we've sometimes gotten a little creative with an E2 investor visa, where an individual might qualify by investing into a business in the U.S. that they're going to direct and develop. But if they purchase a business that perhaps has been running for some years, may have good management in place, then they may be able to come in on an investor visa where they're directing and developing a business, but not having to work 40 plus hours a week. They might be kind of directing, developing, managing the business from afar through their, the computer and email and whatnot, perhaps popping into the business a few times a week, and again, kind of quasi-retired, but using an investor visa as a vehicle to be somewhat retired in the U.S.
What is the best way for a foreign national student to obtain a student visa in the U.S.?
When it's not actually possible to obtain a visa in the U.S., and that's, I think, interesting for some folks, because people will hear about filing in with immigration here in the U.S. or obtaining visas through the consulates. The U.S. consulates outside of the U.S. are the only places that an individual can obtain a visa. And a visa really is a page that goes in one's passport, and I like to think of it as a travel document. If someone has, for example, a student visa issued by a U.S. consulate in their home country, that visa allows them to come to the U.S., and when they present themselves at a port of entry, typically the airport, to Customs and Border Protection, they show a valid visa, and they're able to be admitted pursuant to that visa. And as long as that visa is valid, they can come and go and travel with that visa if they're coming to the U.S. for the purpose of the visa type. So if it's a student visa, that they are coming to study and that they can show that they're in school. So most of the time, an individual seeking a F1 student visa would apply directly for the visa at their at the U.S. consulate in their home country, they first need to show that they've been accepted or admitted to a U.S. Institution or school that allows for foreign students. The school will issue a form called an I-20 that shows that the student's been admitted, the course of the program, the length of the program, the cost of the program, etc. And the applicant has to take that document to the consulate to show that they have been accepted to a school that's authorized to handle foreign students. And then they also have to show the consulate that they have the financial ability to cover the cost of their tuition and room and board, and that they have non-immigrant intent, which essentially means that they're coming to study and intend to return to their home country at the end of the studies. So the consulates typically like to see that they have ties to their home country. Sometimes folks will already be in the U.S. Pursuant to a different visa classification. Perhaps they were here as a child of a parent who's on a work-related visa. So it might be that there's a parent who's here as an E2 investor and a child is here as an E2 dependent child on an E2 visa, but is now turning 21. 21 is kind of that magical age when a child will age out and no longer can be a dependent on their parents' work-related visa. So let's say in a scenario like that, a child is here in the U.S., they've gone to high school perhaps here, and now they're in college, but they're turning 21, but they have a lawful non-immigrant status. Then they can file with immigration here in the U.S. and ask immigration to change their status over from, say, an E2 child to that of an F1 student. And they provide much of the same documentation to immigration here. The I-20 from the school, proof of funds, an ability to pay the tuition, and an indication that they would intend to return to their home country at the conclusion of their studies. But the only way to change one's status here in the U.S. is if you're already in status pursuant to a visa admission.
What trend have you seen recently through your own office as far as nationalities applying for visas?
You know, it's an interesting thing, but I find that I've got clients from so many different countries, and I don't necessarily see trends up and down of individuals from certain countries. If there has been a little bit of a trend, sometimes it will be countries that are perhaps going through an economic crisis or political crisis. So there probably has been an uptick in individuals from Venezuela and perhaps as well Brazil seeking to come to the U.S. And for many of them, Florida, where I practice, is a desired location. So I guess I maybe have seen a little bit of an uptick there. But in general, I find that folks from all over the world are interested in coming to the U.S. to study, to visit, to work. So other than, I suppose, some fluctuations where people are more inclined to want to come because they're trying to get out of an unfortunate situation or a desperate situation, I see a little bit of everything.
Have you seen a decline since the changes in the immigration laws recently, or?
That's a good question. Last year, when we had a change in the presidential administration and a lot of uncertainty about how things were going to play out immigration-wise, and initially, you may recall, fairly soon after President Trump took office, there were a series of travel bans, and then there was litigation in the courts and protests and whatnot. That was a unnerving time for many folks, particularly folks from some of the countries where the travel ban applied. But interestingly, it was unnerving for people from countries who really didn't have anything to worry about. I had Canadians and Europeans who were concerned about what they saw or were unsure about where things were headed immigration-wise. And I did have folks from Europe who said, we really would like to come to the U.S. and we'd like to invest in a business, but we don't quite know what's going on right now with the U.S. immigration system and with the new administration, and we're going to put the brakes on it. I saw a lot of that, I would say, last spring or so in early part of 2017 when things were a little bit in flux and a little uncertain. That maybe initial fear or concern seems to have subsided, and it's kind of business as usual now. Those same individuals that might have said, oh, we're not sure we want to come invest in the U.S. now, I think feel that, okay, we're fine with the idea of it and not so uncertain as they may have been.
I have a question from Tony in the UK. So I own a home in Kissimmee and want to spend 6 months in the country. I was told I had to apply for a visa. Can you offer some advice?
I sure can. So Tony indicated that he's from the UK. The UK is one of those countries where individuals can register under the ESTA program and be able to travel to the U.S. visa-free or with a visa waived for up to 90 days. So if an individual is from a visa waiver country, they're able to come to the U.S. under the ESTA program for up to 90 days, but no extensions. So in Tony's instance, if he has a second home here in Florida and would like to stay more than 90 days, maybe 6 months at a time, then the way to do that would be to apply for a B1, B2 visitor visa. The B1, B2 visitor visa has two classifications. B1 classification is really for business visitors, individuals that might be coming to visit the U.S., but for business purposes like a conference or a trade show, or maybe to negotiate a contract. The B2 visitor is for visitors for tourism, for pleasure, second homeowners, that sort of thing. So a B2 visitor visa would be the ideal visa for someone like Tony. He would need to apply for the visa at the U.S. consulate in London and show that he still has ties to the U.K., that his permanent home is there, that he is likely to return at the end of his visit, and that he has the ability to financially take care of himself while he's in the U.S. So having a second home or having some means is usually pretty straightforward then for obtaining a B2 visitor visa.
Is this something he should come to you for to do, or is it something he could do on his own?
With the B2 visitor visa, that really is one of the visa types that is pretty straightforward. Most visa types I wouldn't encourage someone to apply on their own, but for a visitor visa, that's really something that an individual can do on their own as long as they can follow directions and go onto the website. There's a very good website for most of the U.S. embassies overseas. You've got to complete a form called a DS-160 form electronically and then make an appointment and go in and kind of present the case. In the UK, most likely, the first question that the officer would ask is, well, why do you want to have a visitor visa? How come you can't just use the ESTA program? So he'd need to explain why he wants to stay for longer than 90 days and also show that he still has substantial ties to the UK and is likely to truly be a visitor. They're always on the lookout for someone who might be seeking to obtain a visitor visa as a means to the U.S., but really is going to live in the U.S. or work in the U.S. or do something that would be in violation of a visitor stay.
We have another question. I'm a foreign national, and I had a green card some years ago. However, I moved back to my country of birth. Can I reapply and receive a new green card?
It depends, and it really depends on how the individual obtained the green card in the first place. So, for example, let's say this individual had fallen in love and married a U.S. citizen and obtained a green card that way, but now has moved back and the marriage has ended and now they're single. Then we'd have to come up with a new basis to be able to re-immigrate in a scenario like that if there's no longer the qualifying spouse. Similarly, if the individual had obtained permanent residence through employment and a job offer and perhaps a shortage of U.S. workers, but now has been living overseas, it's not a matter of simply just kind of refiling for a new green card. So it really depends on the circumstances. In some cases, yes, and in some cases, no. And it depends, too, on, some individuals will have a green card and have abandoned it because they've lived outside the U.S. for a lengthy period of time, and they may have to start the process all over again. Some individuals may have lost a green card because of a different reason. It may have been that there's a criminal issue and now the green card has been taken away. That would certainly be something a little bit more complicated.
So Lisa, with all the rumors in the news, have you seen a lot of changes?
It's a good question. There's been a lot of talk in the news, a lot of proposals, some bills put forth. We haven't seen any major changes in immigration as far as immigration reform or the immigration laws changing. A lot of talk about it. And this has been going on for years. I think we are maybe more likely than ever to see some future immigration reform. The tricky thing is nobody can really agree on what that should look like, and there's a lot of competing interests. Unfortunately, immigration, the good aspects of immigration can sometimes get muddied with some of the negative aspects of immigration, and that makes it a little bit difficult. But really, the immigration system that we have, the family and employment-based system, is largely unchanged at the moment. And I don't see major changes in the structural-based system. I know the current president has talked about a merit-based system, and we really have a merit-based system. The employment-based system is largely based on, individuals who are multinational executives or managers, or have extraordinary ability, or have skills that are not available here, have unique talents, degreed professionals, etc. So there may be some tweaks and changes in the future to the immigration system, but at the moment, it really hasn't happened. A lot of talk about it, but not a lot of action.
Lisa, I take it you have a lot of overseas clients. So what is the easiest way for them or for you to communicate with them?
Well, the great thing about technology today is it's easy for clients to get in touch with me and vice versa. The best way, I think, initially is email, and my website as well. Individuals can contact me through my website. My website's pretty easy to remember. It's lisavisa.com, and my email is lisa@lisavisa.com. I'm able to meet with clients either in the office if they happen to be in Florida, or we can do phone consultations or Skype consultations as well. And one nice thing about immigration law is that it's federal law, so I can represent clients no matter what state in the United States they want to live in.
Thank you so much, Lisa. It was very interesting. I really appreciate it. Thank you so much.
Thank you.